Thank you, my lady.
Thank you.
Good morning, my lady. Dr. Perumal, you had time to look at the judgment in the State versus Jam Jam and 12 others.
Yes, my lady.
And are you in agreement with the judgment? If one looks at paragraph 207, where Judge Henny said that your opinion is at odds with that of Professor van der Spey, and what followed on page 56 of the judgment, just to start off. I'm not going to take you through everything as I took you through yesterday, but in essence, would you agree with this finding of the court?
My lady, that's finding of the court made on assessment of evidence. As I said yesterday, my lady, I had been given a certain set of facts on which I drew a report. I came and gave my evidence in chief, and when certain facts that were not available to me, like where the deceased was found, where he jumped off the vehicle, the objects he struck were not known to me, when they were put to me, I then conceded on those new facts. As I was giving evidence, I made quite a number of concessions on the information that was presented while I was giving evidence. And what the judge has done is basically taken all that information and made a finding. It's not for me to disagree with the finding of the judge in this judgment. So I will agree in terms of the evidence that I gave. I can't dispute that. So I just got to abide by what the judge is saying.
Now, you're familiar with the facts of this matter, where you've refreshed your memory yesterday, more or less.
Yeah,
I know you only had the judgment in front of you, so to be fair to you.
Yes, my lady, as the judgment was given to me, I just got some idea of the facts, but I'm not au fait with the details of the matter. I don't know the detail of my report. I can only gather from the judgment what the detail of the case was, but it was quite a long time ago. I don't have that record.
One last aspect on this. Can you recall the opinion of Professor van der Spey, who then in paragraph 207 of this judgment was preferred compared to your opinion?
207.
Page 55.
Yeah. Dr. Perumal's opinion is odd with that of Professor van der Spey, was of the view that it's unlikely that such an injury would be. I didn't exclude that injury. He said it's unlikely, so I can't argue with that.
But what I'm driving at, Doctor, having reconsidered this matter, there's a different opinion. Professor van der Spey is the author, I put it that way, of that opinion or opinions, not only one. I've just referred to one.
Yes.
Reflecting on this matter, would you now accept that that is a better opinion with everything being available at the time then, not only to Professor van der Spey, but now also to you, that you would now accept van der Spey's opinion?
Well, lady, as I said very early on, even my evidence in chief, I will welcome any expert to disagree with my opinion, and if they present some facts, then I will consider it and concur with them. I'm not going to fight with anybody who's presenting a different view. I think that's what medicine is. Medicine is not an exact science. It's to consider the facts, to hear what somebody says, hear the argument for what they're saying, and then say, well, now that I hear what you're saying, I agree. So I can't disagree with what's really written here, my lady.
Thank you, Doctor. I want to move on to the next aspect, and that is provided you with a bundle on the thyroid cartilage horn, 14 pages. The court has not had sight of this, so I wish to hand this up as an exhibit. My lady, that triple S. So that can be so marked. The court pleases.
So marked.
Now, I'm also going to ask that it be thrown up on the wall, these slides. And what this contains, and you had a chance to look at it last night, Doctor.
Yes, I did, my lady.
It's the argument developed by the state on this aspect, and I want to be very precise and brief if I can, whether there was an incision or whether it was fractured. Do you understand that?
I do.
And that the state...
My lady, I wish to place something on record by way of an objection. This follows a trend on the part of my learned friend to be seen in Exhibit Triple S now, Exhibit Triple Q, and several other exhibits, and in particular Triple F1 and Triple F2. None of this documentation has been proved. None of these exhibits have been placed before the court in a proper manner by way of an expert witness or any witness. Furthermore, many of these exhibits, in fact all of them, contain comments and directives and glossa. For example, if we just look at Exhibit Triple Q, right on the top we have a magnified image of a photograph taken by Dr. Perumal, and the magnification is an aspect that needs to be dealt with in due course, but getting to the words there, the mark discovered by Dr. Perumal, ... alleged to be a ligature mark. Now, if we go through all of these exhibits, they all contain extra little additions or comments or suggestions. No scientific or expert source for those has been placed before the court. This is not evidence. The only conceivable aspect of these photographs or exhibits that might constitute evidence is if the witness to whom something or one of these pictures is put comments. But this is evidence that my learned friend should, in the proper presentation of his case, have placed before the court during the course of his case if he wanted to use it. Not a past the post effort to try and slip in and sneak in comments and directives and suggestions, none of which has been supported or corroborated by any evidence. And I have a problem with that, because the question that arises is, what is the status of these documents, and what is the intention of all these extra little bits and comments in these documents? Particularly, many of them have not even been canvassed with the witnesses so far. Thank you.
Lady, my submission would be that this is not a position where the state is trying to sneak in or slip in further evidence. This is argument, it's inferential reasoning. The weight, if there are issues as suggested by my learned friends, that it can be described as further evidence, that can be argued later on. But primarily it is to put, maybe in a more novel fashion, the arguments in the reasoning process based on photographs based at the time of both post-mortems before the court. That succinctly is what the state is doing.
You are testing the version of the accused now. Thank you. And I will decide on the weight to be attached to any of these exhibits that's handed out and marked as exhibits in my judgment. Thank you.
As the court please. So, Dr. Perumal, what the state is developing through these slides, the argument that it was not a decision made based on the evidence of Dr. Khan and the photographs, but it was a fractured, and that the state will argue in the end that Dr. Khan was not in any way incompetent when he presented this as his findings, as a decision. Well, as it was put to him, it was a decision, and he said no. You follow?
Yes, my lady, I do.
Right. Can we then go to slide 3? That's the photo 214. Your comment, please. My lady, is it in order, the light, the front?
Open to testing. Perhaps what is best to give a greater view.
Maybe
and
just the
visibility.
light. No, the bench. And I've got a pointer here if you want to use it, Dr. Perumal.
My lady, may I comment? I think I've got this bundle in front of me.
Yeah.
I don't know whether this is a photocopy of a photograph. I think it is. Then the photo is being transmitted. It's definitely much clearer on the computer screen than it is over there. I think if one looks at that, photo number 214, it's probably better viewed in the photograph album that is in possession. We're losing quite a bit in terms of the photos just being duplicated. And this is probably, it says the photo number 214 on that, which is photo 214 from the exhibit bundle. I don't know what bundle this is.
Yes, we know that's taken at the post-mortem by
That's correct.
Dr. Khan. You're welcome to refer to that photograph if that's better for you.
It seems it's a better quality to me in order to express. Well, firstly, for example, there's a yellow arrow there, my lady. It's going directly over a hemorrhage in the thyroid membrane. So you already lost one important feature.
Yeah.
So what I can't see clearly on that one, I can see clearly in 214 in this exhibit bundle, there's a hemorrhage into the thyroid membrane. As for the closely related thyroid conua, I can't see too much in this photograph to be able to express an opinion on this photo.
Whether it's an incision or not.
No, I can't, not on that photo.
Let's move on to the next slide, where this photograph is now magnified. Slide 4.
My lady, this is very heavily pixelated. What somebody has done, they took a photograph and just magnified it, and it's very, very heavily pixelated that you're losing definition. So I can't really say too much on this. Unless I'm directed to it to comment, I can't really say too much on this photograph. I think it's the same photograph 214 that is just blown up to
Perhaps
show.
you could have access to 214. Do you have it there? Could you have sight of that? Could you view that? Is
On
photo 214 there?
Yes.
Thank you. Will that assist you? Thank you.
I can't direct the witness further if he doesn't want to comment or can't comment. That's, I
He's
understand.
willing to comment. He just can't see the picture properly.
You've got 214 in front of you.
Yes, I have. And as I said to my lady, I can see very clearly, I can see there's a hemorrhage in the thyroid membrane, but I can't really comment on the thyroid conua.
So, do I understand you correctly then, with this magnification as we see there now, and with the argument that the state will have that it's no incision, you don't want to commit yourself to that statement, that it's not caused by an incision?
Well, if one looks at that, again, I'd rather go to say photo 215 in the original. There is no visible incision into that thyroid conua. Same with 216.
Right. Well, let's move on. Slide 5, it's still 214. Any comment there?
My lady, I'll go to the original and photo 216 of this exhibit.
And that's slide 6 then.
Slide number 5 of triple S is 216 of this exhibit C.
Slide 5 is 214. That's what is up on the screen. Photo 216 is slide 6 in your bundle. Triple S. Exhibit triple S. Can we just move to 216?
Okay.
You want to go to 216?
Okay.
My lady, I think my learned friend is incorrect here. Picture 5 in triple S is definitely not photograph 214. Even I can see that. It might be
216.
photograph 216
That's
on
what
a different magnification.
I think that's correct.
Thank you.
Thank
It
you.
says below it, photo 216. The heading says 214.
That's
Thank
what
you.
I'm reading. my lady.
Thank you.
That's a type error. So we're at photo 216, Dr. Perumal.
On triple S5.
Triple S5, and it's. Can we move one slide back, please? Yeah, up in the left-hand corner. It should read 216, not 214. You with us?
I'm with you. That's on page 5 of triple S.
Yeah.
Yes, my lady. Again, I can't see the incised fracture. I can't see a fracture on that particular photograph.
Well, if we move to the next slide, the question, where is the incision? And this argument from the state that if there is no incision, would you agree with that?
In photo 216, it's a blow-up. Number 6 on triple S is a magnification of 216. Like I just said, my lady, I can't see a fracture, incision, or otherwise.
Thank you. Now, you see the argument developed. The next slide, 7, at the bottom.
And then, my lady, the other point I wanted to make in 216, if one looks at the conua, like, this one up, my lady, these are the conua,
You're back to the
original photograph.
Yes?
They look quite similar in terms of their appearance. One is not more hemorrhagic than the other.
Thank you. Then slide 7, you can read the argument developed there at the bottom.
My lady?
Can you comment?
Yes, yeah. Again, if I can look at 217 in the 217 and 218,
The original.
the original. Again, this is not a criticism of the dissector. One would expect, my lady, that the incision would run on the longitudinal plane. In other words, if I go, because 217, 218 is dissected, but go to 216, the scalpel should run in the longitudinal plane, because if you run it in the longitudinal plane, you won't get an artifactual. If you cut across in other words, transversely to the conua. That's one scenario that you can create. Because it's cartilage, you can easily cut the cartilage in that dissecting plane if you're going transverse to it. But if you go longitudinal, you won't cause an artifact. Now
So
let
you
me say,
reduce the chances of an artifact.
there is a chance it's an artifact now because it's cut at 90 degrees to the longitudinal. Now, I want to add that I can't dispute here beyond or on a dogmatic or adamant about the fact that that is 100% an artifact. I can only say to the court that in its pre-incisional state, there seems to be no difference between the two conua. In other words, the one that has the fracture that we see here doesn't have excessive hemorrhage associated with the fracture site. And just as an aside, if one looks at the thyroid bone, one can see that there's a hemorrhage on the inside of the thyroid bone. Yeah, there's no convincing evidence that there's excessive hemorrhage at the site of a fracture prior to it being incised. And even to show its fracture, it would have been wiser to have cut longitudinal and then look for the break. Because if you're cutting a cartilage, which is softer, at 90 degrees, then the chances are you can, in trying to find a fracture, you can create one with the scalpel. And that is the point that I was making. But the rider is, I can't say that, I'm disputing completely there's a fracture because it certainly is an injury one can find. It's a commonest skeletal injury that one can find in cases of hanging. So, on the basis of this photo, my lady, I'm saying that I think that this is an artifact because of the angle in which it is cut.
The way Dr. Carter went about to inspect that area.
That's correct.
Okay.
And prior to the incision, there's no convincing evidence, because if there's a fracture, there should be hemorrhage at the site of the fracture.
Can we move to slide 8? The question is this how an incision made by a surgical scalpel looks like?
My lady, I must say, this is again enormously magnified and pixelated. And only the author who did this can, I think, testify. For me, with the degree of pixelation here, I'm not prepared to comment.
Is the photo on the top right-hand corner, that is clearly the original, not
Yes.
the magnified one.
217.
Would that be able to guide you?
Again, my lady, if one looks at 217, on that picture alone, I can't comment. But 218 shows a little more clearer.
Right, let's then move to 218, but before we get there, that's slide 10. Are you prepared to comment on the next slide, slide 9? Where the argument will be it's a jagged edge?
My lady, it is just too pixelated.
Fine. And on the original?
And on the original, my lady, as one moves on, even to 219 and 220, it does give me the impression that it is an incision. But 219 and 220, my lady, if one looks now for hemorrhage, because when you get a fracture, you find hemorrhage. And actually, there seems to be more reddening on the side opposite. The conua now that we're looking at is the right conua. There seems to be more reddening. So if there's a fracture, I should expect it on that side. Whereas on the left side, where there is a fracture, there's almost an absence of a hemorrhage.
Good.
So if you say to me, am I standing here today saying dogmatically that there's no fracture. It's not an antemortem fracture. That's not what I'm saying. I'm only saying that the probabilities are and the evidence is such that it's probably a artifact. And when I viewed the that cartilage, I know I'm looking at photos, my lady, but when I saw that cartilage at the time that I did the examination, it just looked too clean cut to me.
Thank you. I've dealt now with this slide. You can turn off and the lights can. You made mention, Dr. Perumal, in your curriculum vitae of the Van Breda matter heard in this court, and I want us to have a look at your post-mortem that was handed in the state. This is from Breda, and there's a recent judgment on that by Judge Desai of this division. My hand up, my lady, and can you just identify this document, Dr. Perumal, for us? 6 pages, your post-mortem in this matter.
My lady, I didn't do a post-mortem.
Sorry, not a post-mortem. You're quite correct. You were asked to comment, and you provided your attorney on the 22nd of May 2017 with a 6-page opinion.
That's right, yes.
Thank you. Now, my lady, exhibit TTT. The court pleases.
Somehow.
This was exhibit QQ in the matter
Thank
of
you.
work.
I've deleted that.
Now, you said, Dr. Perumal, that there were lots of evidence in that matter, scientific evidence. You testified it was almost in compartments. You had the DNA, you had the blood spatter, you had the pathology, there's a whole lot of reports. And I was asked to give an interpretation on 5 areas, which I did. You remember your evidence?
There are 5 or 6, yeah. That's correct, my lady.
And that it was basically handed into court and accepted by court. It was uncontested. Now, do you understand? You correct? You were referring to this report.
Yeah, I can't remember my exact words, but I was not called to testify because I think Judge Desai said that the report is handed in, there's no issues with it, and I wasn't required to come and testify.
Well,
so that's how I understood it.
That's how you understood it.
Yes.
We'll get to the judgment now. You said in your evidence in chief in this court, you just handed it in, merely to interpret scientific evidence, and that's really what was required, how to interpret the evidence before the court, correct?
That's what the attorney requested of me, yes.
And your understanding was this evidence was admitted?
That was my understanding, that's correct, my lady.
Now, I'm going to refer to this judgment. My lady, I did speak to my learned friend this morning, and I provided him with an email copy, and I CC'd this honourable court as well with the judgment. My Judge Desai. It's a quite lengthy judgment. I want to quote from this judgment.
My lady, I want to put on record that I got a phone call today. In fact, I got a message today that a judgment was to be sent to me. That was at 10 to 9. I then telephoned my learned friend back and asked him what the message was about. And he said that he had this lengthy judgment of about 300 pages or so. He was going to email it to me. At the time when we had that conversation, he had not yet emailed it to me. So I haven't at any stage had sight of this judgment, and I have a problem with this witness being cross-examined until and unless I get sight of that judgment.
My lady, I'm not exactly sure how it differs from what I've done in the previous two judgments. I've got it electronically here. We can adjourn. I can show my learned friend, I think in fairness, if he wants to raise any further objections to this line of cross-examination, for him to have sight of the particular pages in the judgment pertaining to this report and what was said in the opening statements on the curriculum vitae, the experience of Dr. Perumal.
That's pursuant to what's contained in Dr. Perumal's curriculum vitae.
Well,
That he
specifically
provided
how, sorry,
That you provided comment, but not how the court accepted or found Dr. Perumal's comment in that matter.
he said his evidence was admitted. And this is the evidence that was admitted. And I'm going to refer to the judgment and I'm going to differ with that.
Yesterday you handed two judgments up to the court. That was State versus Jam Jam and 13 others and John Dorth. It was an appeal, John Dorth versus the State. Was that provided to your learned opponent before the court proceeding yesterday?
No, it was handed as I started the cross-examination. It was handed to him.
We'll proceed till 11:30. You can adjourn that time, and then please make sure during that time that a copy is provided to
as the court pleases.
Mr. Constable. Thank you.
I will then move on to a different aspect and leave this for later.
You can proceed on that. You can proceed on
fine.
it.
Good. Now, I want to put it to you, Dr. Perumal, that your findings, well, let me put it this way. It became clear, and one can read the judgment from Justice Sy, that the defense, based on your assistance, disputed three aspects I want to deal with. I'm going to refer thereafter to the judgment that the Sy dealt with it. The first dispute was with Dr. Anthony's findings with regard to the post-mortem examination of Rudy van der Daar. You with me?
I'm hearing you, but I don't know what aspect that is.
I'll guide you now.
You don't have a copy of the judgment here in court like it did for the others.
Excuse me.
Do you have a copy of this judgment?
Only electronically. As I said, over 300 pages, and I didn't print it out.
Thank you. I think you can proceed so long, but at some point, I think it's fair to the witness that he must, like yesterday, that he's able to read at least those relevant pages of the paragraphs that you're going to refer.
My lady, then I am going to leave this matter for the moment. In fairness, there's already been an issue of fairness raised in this court, and I don't want to be unfair to the witness. So I'm not going to proceed with this line of cross-examination until the witness is provided by the State, as well as his counsel, with a printed copy of the judgment. The court pleases.
Thank you.
You also made mention that you were involved in a matter in Zimbabwe, Dr. Perumal.
Yes, the late General Solomon Njuru.
Yes, he was married at the time of his death to the then Vice President of Zimbabwe, correct?
That's correct, my lady.
And do you agree your involvement basically was to assist the family at an inquest at the Harare Magistrates Court, and that was held in 2012, as I understand, or no, 2011.
I'm not sure about the year, but that was an inquest at the Harare.
And you were present there at the inquest?
That's correct, yes.
And you assisted the lawyer for the family, Mr. Takor, spelled Thakor, Kewada. I'm not sure of the pronunciation. Kewada,
Yeah.
for the family.
That's correct, yes.
Good. But you never testified in that matter.
No, my lady.
Certain propositions were put to the pathologist, who were a Cuban-raised Dr. Gabriel Alvera. That's it?
I'm not sure about the name of the doctor. No.
Can you recall, he started off his career, as I understand it, in Cuba. Came to work in Zimbabwe.
That's correct.
That was one of the issues that were raised by the family, his experience in registration, etc.
I can recall, not the detail, but it's a long time ago, but there was some issue with that.
And there was a finding made in the Magistrates Court after a 13-day public inquest, hearing witnesses. You were present, as you said.
Yes.
That General Solomon Majuru could have died of high carbonization due to a fire that engulfed his farmhouse.
I'm aware of the finding, yes.
Yeah. And then the issue of a second autopsy and your involvement was raised at some stage, correct?
That's correct. I requested through the lawyer that we should attempt to do a second autopsy, but the court, or the powers that be, declined that exhumation and autopsy.
Right. And you never testified yourself, correct?
No, I didn't testify.
And no report was handed in at court with
No.
your name on it, correct?
No, that's correct. I didn't give any reports because I didn't have sufficient information on which to base it.
So I'm put it to you, Dr. Perumal, was it necessary to raise this? It's interesting. I would rather argue it's a bit of name dropping, that you were involved there, but we can't say anything about the quality of your opinion. It was not adjudicated on. Would you agree?
No, I'll agree with that. I don't have an issue with that at all, my lady.
And isn't that the same also with the Tertius Bosch matter? There was no inquest that you attended to on the body of the late Tertius Bosch, correct?
That's correct, Milady, because I exhumed the body and I noted that his death, in all probability, was a natural death. And I wouldn't expect anything further to happen because there was a lot of accusations at the time. That's why his body was exhumed, to properly examine. And my finding was the family that briefed me thought that there was something suspicious about the death, and I did my independent finding and found that it is most likely a natural death. Nothing further took place. The point was that we sometimes have to exhume a body in order to perform a second autopsy.
Good. But again, no court pronounced on your opinion there. As you said, it was a natural death, nothing further happened.
It didn't go further.
Good. Now, I've got another matter, and in fairness to you, I will provide you with copies. It's been difficult to get hold of it, and that's why the state has not provided you with it. It's a matter emanating from Douglas in the Northern Cape. There was also a second opinion that you had to give. The state Mrs. Carlo Duplessis, and the deceased was a Mr. Pakedi, Phakedi. This happened in 2015. Do you remember that Northern Cape matter?
Yes, I do.
But we'll deal with it later. I'm just placing that on record, my lady. Now, in a similar fashion, you made mention as part of your curriculum vitae, your involvement in the tragic incident of the Mozambican person Mido Makia.
Yes.
Did I pronounce it correct?
Macia.
Macia, M-A-C-I-A.
Yes.
Now, do you understand, you also did not give evidence in that matter?
No, I didn't testify. I think it was the original pathologist or district surgeon that testified there.
Dr. Kasana.
Skosana, I think it is, yes.
But you were tasked by IPIT to become involved.
That's correct.
And you did consult with the state in the matter, the prosecutor Charles Nizi.
I cannot recall the name, I can't disagree with the name, but I think we had 2 days of consultations with him.
And there was also an opinion obtained from Professor Gert Simon in this matter, and he perused the findings in the post-mortem of Dr. Skosana.
I'm not sure about that, but I can't say that that didn't happen. I didn't see that opinion.
The point is, as I understand it, you were made available by the state to the defense, but the defense never called you to testify, as you said.
That's correct.
So again, we can't have any value on your involvement here. It was not adjudicated by any, correct?
Well, that's true. I didn't testify.
I have a difficulty with this. I don't know if this is some attempted form of character assassination. The witness gave details of his experience and the cases in which he was involved when he was presenting his CV. What is my learned friend trying to achieve by this? When I was cross-examining Dr. Steenkamp, the court stopped me from investigating her conduct in this particular matter with regard to Mrs. Rohde in terms of professional norms and standards. The court stopped me from cross-examining her on that. Yet he's given carte blanche to try and taint this man's character. What is he achieving by all of this?
My ruling in respect of Dr. Steenkamp, because it was, you would recall, the court found that it amounted nothing more than, to that extent, harassing her, and it was undue type of questioning. In this respect, I don't perceive it as character assassination of the expert. This is what's set out in the CV, and I'm informed to what extent he has been involved with legal matters through his expertise. Thank you.
So is the court ruling that this may continue? May I just get that on record?
I would like to hear what the state, to what extent the state wishes to clarify what is set out in the CV of Dr. Perumal.
So the court
decide, yes, I will decide from that how to value his involvement or the extent of his involvement.
Milady, may I just address the court on the aspect of Dr. Steenkamp? It was
no,
quite...
not now. Thank you. Proceed.
Is the court refusing to let me address it on the...
Not now. You can address me in argument. Thank you.
May I just reply?
You may.
My lady, his opinion is being examined. I've already referred this court to matters where judgments were made on his pathological expertise and opinion, and I would just like to get clarity if there are any other such judgments, and I'll get to the Combrador judgment, it has now been shown that no judgments were given on this, where he also were involved with an opinion with his, as a pathologist. It's not a character assassination at all, my lady.
I will allow it to the extent that from the CV I got the impression, and that might still well be the case, that Dr. Perumal was extremely experienced in the field of forensic pathology, and particularly to the extent that it involves court proceedings. If you wish to shed light on that, you may do so.
Thank you.
Well, if I could just answer the last aspect there. In the matter of the deceased Mira Masia, as I indicated, when I visited the scene and I saw what had happened, then I recommended that I would get hold of a very senior person. I don't know whether I said this in my evidence in chief. In my view, they're probably the leading expert in the scene assessment in South Africa, Colonel van der Nest. I phoned him directly myself and asked him to please come on board to properly assess the scene, because I had certain opinions as a pathologist. And he came on board and he also assessed the scene and gave a report. And in part of the process, in terms of managing the case, which I can't manage, it's the state advocate that manages the case, we had lots of pretrial consultations. I didn't know that Professor Simon was engaged in the matter. And the state elected then not to call me to give evidence. They elected to call Dr. Skosana, if I recall. Then subsequently, if I recall correctly, the defense then asked to make me available to them. And I consulted with them, and when I told them what my evidence was going to be, they elected not to call me. And because the evidence was obviously not going to be in their favor, and I had to tell them what the evidence would be. And I then didn't go to court. And what I was doing in the CV, my lady, I didn't present all the cases that I was involved in. I just gave a spread. It's only about 5 or 6 cases to say, these are cases I did the autopsy, this I didn't do the autopsy, this I did jointly with the state, this I did subsequently, etc., etc. Just to show, give some sort of spread.
To what extent you were asked to give your professional opinion?
Yeah, I didn't go into that.
Or comments?
No.
Thank you. You didn't?
I didn't go into the detail of each case as to what the comments were, etc., etc.
No, I'm merely saying that in some matters where you were asked to comment or give your input, you provided those cases.
That's correct.
Doesn't mean that you did the autopsy or the extent to which you assisted.
That's correct.
Thank you.
Thank you. My lady, can we have our adjournment now? There's a new area, and it's quite lengthy, on other wounds with photographs that I want to start off, and I would also like just to get this judgment.
Thank you. How long do you need? Because I would like to take a very short adjournment. The court's only available today till 12:30 and then carry on after lunch at 2. So that if we adjourn now for 5 minutes, we can carry on at 11:30 and then proceed for another hour.
Yeah, that's fine. Thank you.
Thank you, my lady. May I just include a request? Exhibit P, which was handed in by my learned friend. It is to be noted that it was an incomplete article that he handed in. I think he must provide the full article.
I'll do so.
Thank you. Court adjourned for a few minutes. before we proceed, it was brought to me during the adjournment by some of the court staff, Mr. Van der Spey, I'm speaking with you, to you, that you have been very aggressive and rude with him. I'm going to implore upon you to conduct yourself in a manner which behoves as an officer of the court. The court staff are performing a very vital function in our courts, and I and everybody else should afford them the greatest respect. Please, Mr. Van der Spey, could you just tone it down and conduct yourself in the manner which you are required to?
I reject that assertion absolutely, and I do conduct myself, I believe, with great courtesy towards the court staff at all times.
That is what you might believe. That is not what they have informed me.
Well, it seems as if my lady's accepted another version then.
This is not a trial on the issue. This is a request on my part. Please?
My lady, the court has suggested that I am discourteous to the staff without asking my views on that.
Mr. Van der Spey, I'm not going to go into that now. Thank you. You may
I
have
just want to place it on record that I dispute that, but that I endeavour at all times to be courteous to all members of the court, and I think that is borne out by anyone who is in this court.
Not necessarily. I don't view it that way, but you may have a seat. Thank you.
Pleases, my lady, I wish to hand a bundle of documents. I'm not going to introduce it to the record. In fairness to the witness, it's a matter where he was involved in the Northern Cape, and I want him time to look at it. I'll also provide a copy of this bundle, 7 different documents to the defense. Dr. Perumal, if I recall now correctly, I did mention this matter emanating from Douglas. You see it's a 2014 matter, and you provided in the second bundle before you a report, a post-mortem examination report on Mr. Pakedi.
That's correct, my lady.
And I wish this witness to peruse it when we adjourn, and when he's ready, I want certain comments made, request these comments on this. Just for the record that you know what you've got in front of you. The first document is the Lykskou deur die staat. Sorry, it is in English. Post-mortem by the state. You've got that?
Yes, I got it.
A22 in the docket. Then it's your post-mortem report, marked bundle 2 in this. I'm not exactly sure what was the date, but it's the 26th of September 2014.
That's right.
And then your histology report dated the 11th of September 2014, you've got that?
Yes.
And then a medical legal opinion by yourself dated the 13th of May 2015. And it consists of 15 pages, correct?
That's right.
Then there was a further post-mortem after the body was exhumed, the remains.
Yes.
And that's by Dr. Murat.
That's correct, yes.
The copy we've got is unsigned. And then you provided the second report dated the 23rd of February 2016.
That's correct.
And this is 19 pages, correct?
That's correct.
And then we've got the judgment in this matter by the High Court. And I'll find and I'll provide it to you where the judge comments on your involvement as well as the state pathologist's involvement. And we'll deal with that later. You can hold on to that at the moment. You can put it aside. For the time being, please. Thank you. Milady, as indicated before the break, I would like to move on to a new matter, and I've also made use of slides referring to photographs taken at the autopsy of Dr. Khan, and I would like this witness to comment on the nature and the origin of wounds as depicted on these photographs. May I hand up a bundle to court and to the to the defense witness, titled Other Wounds, and it makes reference to photographs in the post-mortem.
Thank you, Milady. Before this is even accepted as an exhibit, I want to reiterate my objection to all of these bundles that have been handed up. I see that this once again contains a whole lot of comments, personal observations, diagrams, questions, none of which was included in the case of the prosecution, and once again, if I might coin a phrase, is an indication of him wanting to have a second bite at the cherry.
Lady, I've got nothing to add other than I've already made my submissions on that. I disagree.
On his face, comment is noted. Thank you.
Thank you. Can we have the slides? The first slide we've got up there, that's just the introduction.
Mr. Rohde, whilst we're all staring at the wall, would you like to have a seat perhaps next to your attorney?
Now, slide 2, photograph 103, and you're welcome to look at the album. This is not by any way, some of them are enlarged. However, let's deal with photograph 103 up there. Yeah, we can have the light front turned up, please. Now the question is, and can you comment on it, the left upper eye, what would your opinion be? Is it a graze or an abrasion or a laceration that she suffered?
Lady, it could be classified either as a deep abrasion or superficial laceration.
And what do you think is the cause of that? Given your knowledge now of this matter and what was presented in evidence that you followed, as was stated to the court when you started your evidence in chief, Doctor.
My lady, firstly I would say that's a result of blunt force trauma. Either an object had impacted the corner of the left eye, or the left eye had impacted onto an object. I can't go more than that. If a scenario is put to me, then I'll say yes or no, it's consistent.
Thank you. To go further into the same photograph, the next slide, would you consider that a blunt impact, as depicted there? Also photograph 103.
My lady, I'm not convinced that that is a separate injury. I think that is extravasation of blood. Red cells is what we're looking at there, change in color, extravasation into the very loose or lax connective tissue over the eyelid. Now, if one looks at these photos even earlier at the scene, you can see it's much less. It's not well expressed early on, and with time it just gets better expressed. That doesn't mean it's a vital reaction, it just means a gravitation. Just like you get hypostasis, gravitation is pulling the blood there. So I'm not convinced, because if it was an injury, because it's such a loose connected tissue, it's easier to get swelling, periorbital swelling. So the lack of the swelling with this kind of discoloration, I tend to say that it's more extravasation rather than another impact.
So if we can just go back to this slide 2, so thank you, where I point there.
Yes.
And up here on the, just under the eyebrow, you say this is not two separate injuries.
I'm not convinced that they're two separate injuries. I'm saying to the court that that's a gravitational pull of blood into the eyelid.
But can you really rule out an opinion that that is a separate, as I indicated there on?
I can't rule it out, and I'm not sure if Dr. Khan saw it as a separate injury, but I can't exclude it. Definitely, I won't say I'm now being categoric that that is entirely a extravasation. But if one looks at the photo in 103, I'm not convinced.
Still on photograph 103, if we can move to slide 4, what does that, next slide 4, what does that spatter tells us? You see that? I think it's...
That's dried blood. That means that means that this injury has blood emanated from the injury.
And the mechanism?
That
why and the direction, we'll get to the document as it developed here on the slide.
Lady Icon from photo 103 make any comment in terms of the direction. It's just dried blood.
Okay, well, let me show you the argument on this as I put it out here. The next slide, 5. Can it be said and argued that it's in upward direction, the force coming from, as it's depicted here in the yellow line, going upward?
My lady, I do not claim to be an expert on blood spatter, but I think I do have reasonable amount of knowledge as a pathologist. Now, if there's an injury, we have what is called the primary source. When there is another impact upon a blood source, then only will you get spatter from it. Now, that has got no particular shape, because if you have blood spatter, if that was an injury there originally with a blood source, and the blood was not coagulated, in other words, still fluid, then if there's an impact on an already pre-existing blood source, then the blood, because of its viscosity, will be propelled in the direction in which the force is applied, and it will form like a tadpole, be a round forward section with a tail. Now, I don't want to sound disrespectful. If I have to look, I can't see a blood spatter in the form of tadpoles to enable me to give a direction. So whoever's done that, I don't know their scientific basis, understanding of viscosity of blood and things like that, my lady.
What?
But from my understanding, that you cannot work out a direction, because that is simply dried blood without any particular shape that I can formulate an opinion on. So I'm not convinced that is spatter on an already existing blood source.
Well, we can move back then to slide 4. There's a wound.
Yes.
Correct?
Yes.
On the, how would you describe that wound? Where it is?
That's on the supraorbital ridge,
Right.
the prominence of the eye socket.
And above here, what do you perceive?
Sorry, my lady, I cannot see. That thing is...
I think the battery life has gone. There's a circle around.
Yes, I
You
see a
that?
circle, my lady.
Well, and look on your,
Yes.
perhaps better here, on your bundle exhibit.
Or
you-
103.
You agree that's blood?
Yes, I said, my lady, that's blood, that's dried blood.
And where does it come from? Animated?
I think that the source is from that deep abrasion, superficial laceration, and as the person lying there, it's probably gravitating even in that direction. But I'm not convinced that that is now blood spatter from impact on a pre-existing blood source.
Now, as I understand the accused version, slide 6, it was when they were returning from the room where he visited the Lenatesky that he recalls that the deceased fell. Now, have you been to the scene?
Yes, I have.
And you've been to that row, I think the 400s, and then where their room was in the row 200. You've walked around there, is that
Yes,
correct?
I don't know the numbers, but I've got an idea of the scene, yes.
So on return, there's a low, very low returning wall, and we can, retaining wall, and then a bit of scrubbery, and then you get to the actual room. So I can describe it as that. You can have a look at the scene photographs as well if necessary. But if that is what the evidence is of the accused, how he perceived what happened with the deceased. Now, if that could cause what we were looking at now, the wound on the left eye, and if we can move to the next slide 7, the argument would be if the deceased fell forward, in what direction then, if that impact caused that injury, where would the spatter go? If any spatter, from your experience.
Yes. My lady, if the deceased had fallen and the orbital ridge had impacted on any blunt object, whether it's a wall or anything, the blunt object, that will then create a wound. But you're not going to see the spatter at the time of creation of the wound. To get a spatter, you have to have impact on the blood source. So I can't tell you which direction that wound was sustained. I'm afraid I can't.
Can you perceive such a wound caused by falling in that manner?
It's possible that she could have sustained the wound by falling onto the wall as there is a figurine onto it, but it's more likely something more broad that would have caused this, because if she fell, as she's shown and sketched there, I'm more likely to see a deeper laceration than the abrasion or superficial laceration that I'm seeing.
Do I understand your evidence then that you don't think that injury above the left eye was caused by this fall?
My lady, it's possible that she got that injury, but I say if she didn't break a fall, she can get that injury. But I'm saying that I expect a deeper and a larger laceration.
So I just want clarity. What you're saying us, in your opinion, it must have been a different incident, blunt force, causing that injury and blood above the eye.
And probably a broader contact surface.
And in your vast experience, Dr. Perumal, could that be because of a fist, for instance?
Milady, all I'm saying is it could be a force applied to her. So if it's a fist, it normally won't cut the tissue. It won't cut it. It will more likely leave a bruise.
But the knuckle cut?
Again, my lady, there's no associated bruise around it. It's just a deep abrasion or a superficial laceration. Again, terribly sorry if I'm not helpful to the court. I can't push it further than I am able to.
I can understand that. I've developed this argument further in the next slide 8. Just read what is stated there. Can you comment? Do you agree, disagree?
If the deceased fell straight down on a wall, theoretically the spatter position is possible. Why are there no scrapings above the wound, i.e. on the forehead? The wall would not have given way to the head, which scraped against the wall, injuring surrounding tissue and structures. According to Accuse, this fell on a low wall. This scenario is not attainable.
My lady.
Sorry. I do have a problem with this information that's up. It seems to be based on something which requires some expert to have supported the argument. So perhaps you want to take that information and simply just put a question in your own words to this witness.
As the court pleases, we can move on. Well, if we direct the operator. Let me rephrase. Forget about the slide 8 then. If there's a ring on a finger and it's used as hitting somebody, would that be able to cause that wound?
I will say it's possible that a fist with a ring on it could cause it. I would expect then for some of the tissue to be lifted in the direction in which the swing was applied. Again, it's not excluded.
Now, we can move to slide 10. I'm trying to understand on the Accused version what injuries were caused by the deceased falling. Now we know there's tarred surface where they were walking back, correct?
I'm not sure if it's tarred or corrugated, but it's rough.
Rough surface.
Yes, rough surface.
That's better put. Wouldn't you expect abrasions on her knees and elbows or insides of the hands as she was trying to break the fall?
If somebody had fallen and was attempting to break the fall, then I expect to find injuries in the prominences of the body, like the knuckles, the elbows, etc.
And we know that she was wearing a gown, and this gown was presented here in court, short sleeves. Have you seen a clean gown used by a spear in the rooms, Dr. Perumal?
I saw the gown when it was presented here, my lady.
And it's a short gown, correct?
Yes,
Round
I think
about
it was just at about the level of the knee or so.
Exactly. Now, slide 11, autopsy photo 104, the shoulder. Can you give us opinion on how that injury occurred, given the version of the accused?
My lady, again, that is an abrasion. An abrasion as a result of blunt force injury. Whether, again, something was applied to the shoulder or the shoulder was applied to something, that's what we will have a result in. So, it's an abrasion. Once more, my lady, it said, could it be a result of a fall? Yes, if that area had fallen onto something rough.
Then we can move to slide 13, photo 92. that be caused by a dumbbell or by something different, falling? Your opinion?
Milady, it'll be hard to say now because whatever's happened a few days, about a week before, and there would be quite a bit of shifting of the blood. It's not going to be, this wound as we see it would not look the same in the hours after it sustained the injury. In the process of healing, there will be shifting of the cells, and it's not going to totally reflect an instrument now as we look at it a week later.
Then slide 15, photograph 161. Can you venture an opinion on how these wounds were sustained?
Yes. Again, these are abrasions, and they're on the knuckles. 2 of them. In fact, there's a cluster. You were looking into blown up. There's a cluster. The superior one is a cluster, and the lower one is a single abrasion. Now, either she fell onto something with her hand that impacted, or she impacted something. And it's not necessarily that she fell onto some impact on her. Now, if she walked past and struck something, or she fell onto something, or hit something, then you can get this. All it tells me, my lady, is that there was sufficient force to remove the skin.
Slide 16, photo 144 from the autopsy. How was that wound sustained?
Again, that is a bruise. Once more, it's a blunt force injury. The superficial layer of the epidermis is not removed. There's bleeding under the skin. Either she impacted something impacted her, could be as a result of a grab, for example, because the bruise, something soft against it, not something rough.
Slide 17.
17, that's an abrasion on the right foot, second toe. Once more, my lady. The superficial layer, the epidermis is taken off. There's some associated bleeding, but I think when it was cleaned out, it was clearly seen as an abrasion. It's either she impacted something rough with her toe, or something rough impacted her.
Right. Now, we knew that she was walking bare feet that night on that surface. Can you comment?
Sorry, my lady. I'm not sure whether the numbers are correct here. If we could just go back to number 17. It says here that it is, in one place, Dr. Khan, Autopsy Album, photograph 184, and the other one it says photograph 84. Can we get clarity on that, please?
I believe well, I'll have to double check. I don't want to speculate.
Please get back to me on that. Thank you.
I'll come back to that. Let me get back to that. Now, can you say whether it was while she was walking or falling that she injured herself in this manner, as depicted on that slide 17?
It's possible that she was walking and she kicked something. It's possible that she could have sustained it if she fell.
So both are possible.
Both are possible.
That's also what we're arguing on slide 18.
Similar etiology.
Slide 19.
Again,
My lady, once again, I just want to place on record, and as vehemently as I can, in my gentle manner, that I have a grave objection to this form of evidence presenting and cross-examination. If we just take, for example, slide 18. Look at the comments there. That is so inappropriate. There is not a vestige of evidence to support these comments. Who is the expert? My learned friend. How was this wound on the big toe of the left foot sustained during walking or a fall? The deceased did not attend to it or clean it before going to bed. This is not proper, this is not fair, and this is not acceptable. And it is irregular.
It's not a statement, it's a question. It's his question that's set out there. Is it not, Mr. Van Dyke?
Yes, my lady. I could have taken the photograph of it and formulated the questions in the same manner. This may be a novel way of doing it, but it's the same way I would have done it in any event in cross-examination, my lady. But I think we've dealt with that objection.
Okay. I just have a problem, as I've indicated before, with the setting out of expert kind of testimony through the questions.
That's not what the state intends doing with this.
In this case. Thank you. I'll put the question to the witness.
My lady, the state says it doesn't intend to do that, but de facto that is what the state is doing, and the court is allowing.
Thank you, Richard. Now, I've dealt with the slide. You've seen these wounds now from the autopsy, the collection, shown to you again, Dr. Perumal.
Yes.
In your opinion, would that all of them be related to that fall coming back from the room, or can it also be that at different stages? I'm not talking about the toes and walking bare feet, the other wounds. Those wounds had been sustained at a different time in the early mornings of that Sunday.
My lady, I have a problem with this question because repeatedly my learned friend has not accurately and truthfully and correctly put the accused version to this witness of exactly what happened at that fall and how it occurred. When he does that, there might be less of a problem. But he's only put half the version, and the same applies to this entire bundle that he's produced. The fall did not occur as it has been put to this witness.
Okay. You will have an opportunity, no doubt, in re-examination to put that to the witness. Mr. Van Dyke?
Well, may I just...
Sorry, before Mr. Van Dyke was raising his objection, I just wanted to know, you must specify to the witness what injuries in particular you refer to. I know that you have in piecemeal dealt with it, but I think you've got to specify those injuries. And yes, like Mr. Van Dyke said, I think you need to say to the witness, this is how Mr. Rohde says these injuries were sustained.
Well, the court's referring to Mr. Van der Spy, but it's not for Mr. Van der Spy to direct me that I have to use the exact evidence of what the accusers placed it. This is an expert witness with vast experience as a district surgeon, and I would, with respect to this, I may ask him to comment from his experience, and he knows the evidence. I'm not going to repeat it, what was placed before court, whether it's by this accused or Dr. Khan. That's my general submission, but I will deal with photograph per photograph as the court has directed me.
You must be cautious not to mislead this witness.
I don't want that at all, my lady.
Okay, thank you.
Dr. Perumal, you follow our reasoning here. You're the expert. You've seen victims of assault before, correct?
Yes, my lady.
Victims in motor vehicle accidents.
Correct.
You've seen husband and wives fighting with each other, right?
Not really
Well,
seen
well,
them
no,
fighting,
sorry,
but seen the effects of it, yes.
Let me rephrase it. And you've heard the version of the accused, correct?
I read
You've
his
read it.
testimony, yes.
You understand his version.
I do.
Right. Now, as I said, leaving out the injuries to the toe, we've gone through each of these wounds. My first question was an incident, as the accused testified, that coming back from the room where he was with Jolene out the sky, the deceased fell and left the area where they were walking and fell next to the pathway. Is that an accurate reflection? Does that jog your memory for what the accused said?
More or less, Milady. That's how I understood it.
So my question was, in this whole bundle, apart from the toe injuries on the foot, can each one of these injuries unequivocally be related back to that fall or not?
Milady, all of them are blunt force injuries.
Sorry, I didn't hear your answer.
All these injuries are blunt force
Blunt
injuries, yes. I would say most, if not all, of the abrasions could be as a result of the incident described by the accused, except possibly for the bruise on the wrist.
And why do you exclude that?
Because if she had fallen on a rough surface, it is unlikely she'll end up with a bruise. It is more likely she'll sustain an abrasion.
So how must we understand where did she obtain that wound? Can you comment? Your understanding of the evidence?
Yes, either if I understand the evidence that he struck out at her, he could have injured her in that process, or if he had restrained her, that could result.
Now, you've handed in a report that is Exhibit E before the court. Let me just put it before you to remind you of that. And you're aware that this report dated the 16th of August 2017 with a cause of death consistent with ligature strangulation was presented to the bail hearing in this matter.
Yes, just a correction. Date is 2016, not 2017.
2016.
Yeah, but that's the exhibit. Sorry.
Now, a lot has happened since, and you've heard a lot of evidence since.
Yes.
But at the time, are you still comfortable to state that your observations at the time, the date of this report, 16th of August 2017, that this is the only and accurate reflection of your opinion of the cause of death?
No, my lady. I gave evidence, Chief, and even on the cross, and some of the questions posed by the court, I said it's consistent with ligature strangulation. It definitely isn't the only cause of death that I entertained. And sorry, I just want to say, because as I explained at various stages, the findings in the neck could well be as a result of throttling or manual strangulation. And I indicate to the court there are two competing causes. And the injuries that we see could be seen in both scenarios. But because of the appearance of the ligature mark and the saliva, I favored the version that, or the cause of death that is more likely to be hanging, the probability is more likely to be hanging. But there's no way I can stand before this court and say that manual strangulation is excluded beyond any reasonable doubt. So I'm not saying in this report that that's the only diagnosis that I'm entertaining.
Now, Dr. Perumal, at the time when you wrote up this report, were you also of that view as you've now succinctly expressed it?
That's correct. That's why I said, my lady, I didn't make any findings, definitive findings at the time. And I needed to have the findings of the first autopsy.
But
I
why?
found some features that were consistent or could support asphyxia. And therefore, I said, I didn't say cause of death, ligature strangulation. I said it's consistent with, and like I said many times, my lady, I cannot make a finding just on the autopsy.
Why then, Dr. Perumal, was that not put in your report, that qualification, as you now very eloquently, if I may say, have elaborated on?
My lady, I can't, it's not our practice to put all the other things that we are considering, but simply to say it's consistent with ligature strangulation. It's not the practice to say that A and B and C must be considered.
But don't I understand your opinion that, can I understand it also that these other aspects that you were considering, right, that could well have been in a way consistent also with what were viewed at the second autopsy by you?
No, because I didn't make any definitive findings in the neck. And I said because of the challenge with the second autopsy in the neck, I needed more information. And now that I've got that information both photographically and in writing from Dr. Khan, and I could even show you the thyroid membrane, etc., all those hemorrhages, I now put before the court that that must be considered.
But again, I can't understand, Dr. Perumal, why was that not, as a caveat, put in this report?
I didn't have the evidence at the time of the second autopsy to entertain that to the same extent that I can entertain ligature strangulation.
I understand that, Dr. Perumal, but you did think about it at the time. You were considering you need more information. Why was that not put in the report?
Yeah. My lady, that's just the standard practice in which we work. We consider what pathology it is and say it's consistent with, and then we entertain whatever else comes our way. This is not to lock the diagnosis. It's not really. That's why I said it's consistent with. That's just practice.
You didn't make definitive findings and that was subject to you getting more information.
Yes.
Would this report, Exhibit E then, would you say that, not that you marked it that way, but could it then have been a provisional finding?
No, it is a finding based on the autopsy.
Based on what you had worked?
That's what I've seen, yes. Unfortunately, there was a time when we kept on writing, no specific anatomical cause of death was established. And it didn't help anyone with the further investigation of a case. So then we move to say, can you say it's consistent with this? Because that's a little more helpful in terms of directing an investigation. But we originally started off by saying no specific anatomical cause of death was established. So that's the basis. And like I said, when more information comes to hand, I can then express a comment.
I understand that, Dr. Pearl, but surely these other factors that you were mulling over in your head, you would agree that that is important for the investigation team to take further. Isn't that so?
Yes, and I knew that there was already a first autopsy done. My lady, as I was saying, I didn't see all those bruises that Dr. Khan had observed at the first autopsy. It was just so much of post-mortem artifact and reddening in the area of the neck that I said I couldn't make a finding. I'm not disputing it was there. I knew it was there, and I know the probability will be photographed, and that will become available. So I can't entertain the various diagnoses, simply to put it like this, and that is practice.
Were you consulted in person on your report before the bail hearing started?
No, what I did was, once I did the autopsy, I met with Mr. Daniel Witz, the attorney in Johannesburg, and I explained him what the findings are.
And did you explain also to him what you've just told us now, that there were other thoughts in your mind?
This would be privileged, my lady. This is not evidence that can be elicited.
I think he's privileged. I think you should stick to what you said a little.
My lady, the aspect of a fair trial and what happened at the bail hearing is put into play as a defense. This is an expert witness. It's relevant as to, and I'll argue that later. Now, I actually, in fact, might put this argument to the expert. I'll refrain from him answering what he said to the attorney, although it was indicated that Mr. Daniel Witz is going to be called, and I haven't seen any affidavit on what he's going to testify. But we've heard the problems that they had, that he was accused of murder at the time. And that's where I'm heading to, my lady.
Well, you can achieve that without having to ask him what he informed or did not inform Mr.
I'll respect that ruling. Dr. Perumal, based on your report, consistent with ligature strangulation, and based on the report by Carol Nader, which is not a clinical psychologist, been through that area of the evidence.
I don't know anything about that witness that you mentioned.
Yeah. I'm just saying, your opinion here played a major role in the argument at the bail hearing that charges should be dropped. There's no case against the accused. You understand?
I understand, but I don't know. I didn't play any role in all of those things.
I won't take it further. That's a legal argument that we'll have. My lady, it's almost 12:30.
Thank you. Thank you. Court will adjourn until 2 o'clock.
That's
Thank you.